In March 1963, police arrested Ernesto Miranda in Phoenix, Arizona, bringing him to a local precinct for questioning. After 2 full hours in an isolated interrogation room, he signed a written confession. No attorney was present. At the top of the page he signed, a pre-printed typed clause stated that the confession was given voluntarily. It explicitly declared Ernesto was fully aware of the protections available to him. Ernesto Miranda signed his name to that claim. Yet throughout the entire 2-hour interrogation, the police had never actually told him what those legal rights were. A criminal trial is a public, adversarial proceeding, but an interrogation takes place in secret, isolated and entirely controlled by the police. Before 1966, the Supreme Court evaluated confessions using the due process voluntariness test, an approach stemming from the 1936 case Brown v. Mississippi. Under this regime, judges applied a totality of the circumstances analysis. They looked back at the facts of each individual case after the trial to guess whether a confession was freely given. But this backward-looking analysis faced an insurmountable evidentiary problem. The interrogation room is closed. There are no impartial witnesses. Proving whether psychological coercion occurred behind a closed door is virtually impossible from the outside. To fix this, the Warren Court moved the constitutional frontier. They relocated the protective focus away from the courtroom, directly into the interrogation room itself. Chief Justice Earl Warren, writing for the majority, delivered a strict, bright-line rule. This decision replaced a subjective post-trial guessing game with a rigid, categorical mandate. The majority's chosen remedy was the creation of a prophylactic rule. A prophylactic rule is a safeguard constructed by judges. It goes beyond the bare text of the Constitution to protect an underlying right. The warnings themselves are not enumerated in the Constitution. They are the judicially crafted device meant to dispel the inherent compulsion of the room. The suspect must be clearly informed that he has the right to remain silent, and that anything he says can be used against him in court. He must be clearly informed that he has the right to the presence of an attorney, and that if he is indigent, a lawyer will be appointed to represent him. A suspect is permitted to waive these rights and answer questions. However, the state bears a heavy burden to prove that any waiver was made with genuine understanding and free will. The court applied this exact checklist to engineer a universal shield against the closed room, reversing convictions in 4 consolidated cases: Miranda v. Miranda, Westover, and California v. Stewart. The 5-4 decision immediately fractured the court, prompting the dissents to launch a profound structural attack on the majority's authority. The deepest objection was separation of powers. Were the justices fulfilling their judicial role or improperly encroaching on the duties of lawmakers? Justice John Marshall Harlan, joined by Justices Stewart and White, argued that the new rule lacked any grounding in the text or history of the Fifth Amendment. His view of the majority's action was uncompromising. Harlan maintained that the traditional due process voluntariness test, for all its messiness, was the only honest constitutional approach. He warned that the court's new mandate was a deliberate calculus, an approach unjustly weighted against legitimate law enforcement. Justice Byron White, also joined by Justices Harlan and Stewart, launched a direct attack on the Warren Court's factual assumptions. He argued that the majority's core empirical premise, that custody is inherently coercive, was merely an assertion, completely lacking demonstrated proof. White warned of severe social costs, predicting the rigid remedy would return guilty defendants to the streets at the expense of public safety. Justice Tom Clark, dissenting in part, echoed the concern over judicial overreach. He objected to discarding the totality of the circumstances framework wholesale, advocating instead for a modified due process standard rather than a rigid code. These dissents laid bare an enduring tension. Is Miranda a necessary constitutional interpretation to protect the vulnerable, or is it policymaking dressed up as law? Following 1966, subsequent courts spent years qualifying the warnings. The narrowing began with a public safety exception in the 1984 case, New York v. Quarles. The court also allowed for the impeachment use of unwarned statements, letting prosecutors use them not to prove guilt directly, but to attack a testifying defendant's credibility. Later rulings admitted the physical fruits of unwarned statements, and required that any invocation of the right to remain silent must be completely unambiguous. Yet, when Congress attempted to explicitly overrule the Miranda decision by passing a new federal statute, the court pushed back. In 2000, Chief Justice Rehnquist, a longtime critic, authored the Dickerson opinion, striking down the legislative attempt to bypass the 1966 ruling. The warnings became one of the most recognized features of American law worldwide, solidifying their cultural power, even as the Supreme Court systematically narrowed their legal reach. In the decades following 1966, subsequent courts spent years evaluating and qualifying how the warnings operate in practice. The narrowing began with the creation of a public safety exception in the 1984 case, New York v. Quarles. The court also allowed for the impeachment use of unwarned statements, letting prosecutors use them not to prove guilt directly, but to attack a testifying defendant's credibility. Later rulings admitted the physical fruits of unwarned statements and required that any invocation of the right to remain silent must be completely unambiguous. Yet when Congress attempted to explicitly overrule Miranda by passing a federal statute, the court pushed back. In the year 2000, Chief Justice William Rehnquist, a longtime critic of the ruling, authored the Dickerson opinion, striking down the legislative attempt to bypass the 1966 ruling. The warnings became one of the most recognized features of American law worldwide, solidifying their cultural power even as the Supreme Court systematically narrowed their legal reach. Ultimately, the focus returns to the isolated suspect, seated in an empty metal chair with agents of the state. The empirical debate remains heavily contested. Do these warnings actually protect suspects from coercion, or do they merely handcuff law enforcement? We are left with an open question. A rule born to protect the vulnerable in a closed room, does it actually constrain power, or does it merely provide a checklist that ritualizes its exercise?